but there will be an injunction. By then you have either concluded the agreement or you will get the injunction, and of course the longer the clock is ticking, the better the position of the patentee, and at the end maybe even the patentee may drag out the negotiations and just wait for the injunction to come. The other school says no, a complaint is sufficient notice. That's one thing. That has to be sorted out. Another thing, and that's more interesting, is what about this friend offered by the patentee? And so far the patentee came, okay, our standard license is this and that, and our standard royalty is $1 per piece, and please accept this. It was of course more detailed, but that was the information why they gave, and the courts came now and said, well, we cannot determine what is a friend royalty, and we don't want to do that. That's for the parties to negotiate. However, what we can do is check whether the offer is friend under legal terms, that it is fair, reasonable, non-discriminatory, especially non-discriminatory. And to this end, the patentee really has to set out why the offer is friend. And that we had a preliminary communication by a court in a pending procedure, which basically said, okay, you have to communicate. If you rely on other licensing agreements, you have to present them to court, given the case under a secrecy order. You have to explain why these are comparable. You have to make provisions in case the patent coverage shifts. So basically, you have to explain your patent policy to the court. That was one thing. In another case, the court simply said, it's not enough if you just say, okay, we grant you a license at a royalty of X per piece. You really have to explain why it's friend. So if I were to look into the crystal ball, and these are all first instance decisions or pending procedures, and we don't have any ruling from a high court, but if I were to look into my crystal ball, we might have a dispute to what extent the patentee has to explain its patent policy to the court if it wants to get an injunction, which may lead to a situation that seeking an injunction may not be so attractive anymore, because you may either not be able to convince the court, or you have to disclose certain things you don't want to disclose. So that's where we currently stand. Nutshell is injunctions are granted, whereas until ECJ decision they were granted as a matter of course, more or less, because there was always a dispute about the royalty. There could be a tendency now that it will be more difficult for the courts, and certainly for the patentees to get an injunction, and certainly the courts will require more from the patentee, more explanation, and possibly also from the defendant in its behavior than was before. Now, there is, on the other hand, the good news, there is the prerequisite for all this is that the defendant is a willing licensee. And if you have an unwilling licensee that drags out negotiations, makes unreasonable offers or whatever, then again, the courts have been, even post ZTE, Huawei, been very adamant to just to cut it down, grant injunction. Okay, I'm over the time, I know. Okay. Thank you.
Okay. We're trying to give just an overview of what the current trend is at a high level. I think that's very interesting, that the issues there in Europe, the injunction is certainly an important issue in the States right now, and I'll come back to that later, but it's interesting to hear in the aftermath of the ECJ's decision last year regarding injunctions that is a key issue in Europe, and I think it's an issue that India is considering and addressing, and so let me turn to Sanjeev for an overview of some of the issues here in India, and then Deepak, I'll ask you to follow on with the issues, and then we'll hear from the corporate perspective what the current state is here. So again, an overview of just what are the hot button issues in India.
Thank you, Patrick. Good morning, everyone. Thank you, co-panelists. So far, we have an interesting update from Stephen on the European perspective. In India, so far as we all understand, beginning from 2013, we have seen an encouraging sign for the innovators. The ACPs have been enforced. Probably we have 3 sets of cases so far. One, the Ericsson's 8 patents and the suits against 5, 6 defendants. Then there was a suit by Bringo, 2, 3 suits by Bringo, including their ACP action, and recently the suit or the action by Dolby based on their 5 ACPs against 5 defendants, 5 implementers. Now, the learning so far from these 3 broad actions in India, that injunctions or interim injunction as such can be granted. The courts are inclined to grant even ex parte injunction. Ex parte means without hearing the implementer. There had been a criticism of these decisions, the ex parte decisions or the interim decisions. However, fact remains, based on those ex parte injunctions, party negotiated, they came out and they put their proposal. Court, based on the agreed terms, proposed the interim royalty. Those interim royalties were further modulated in view of the parties' disclosure of certain license or the terms which are applicable in the relevant area of technology. But the arrangements as of now in the cases involving Ericsson and Dolby, that the implementers whose products are accused are paying certain amount of interim royalty to the either Ericsson and Dolby. At the same time, the implementers have raised issues of anti-competition. The actions and the complaints have been filed before the Competition Commission of India. Those issues are still pending adjudication before the High Court of Delhi. The issues regarding the interplay of the Patents Act and the CCI, what role the Competition Commission can play in view of the substantive provisions of Patent Act. The writ court at the first instance, they found the 2 jurisdictions are separate and the Competition Commission can still look into, though the Patents Act provides substantial remedy and carve out also measure for anti-competitiveness, still the Competition Act has its own role to play in view of peculiar provisions and also the nature of remedy which is available under the Competition Act. Having said that, I can say that it is still in early days. Adjudication relating to the issues before Competition Commission of India are to be finally adjudicated by the Division Bench of Delhi High Court. It may reach to the Supreme Court. We may have some kind of certainty once we have a final verdict from that channel of the complaints coming out of the CCI. And secondly, even in the suits involving Ericsson, where the evidences are being led, the trials are underway, probably we may hope the final adjudication and the final decision by the Court of First Instance maybe in a year's time, and that could provide a proper Indian perspective. Right now, what we are looking at the interim measures, pending trial and final adjudication. Having said that, from the innovator perspective, it is a good sign that the courts in a given fact situations are inclined to grant ex parte or the interim injunction, whether bad, good, indifferent, but courts have taken the approach in their own wisdom based upon the facts of the cases. And that is a good sign for the innovator companies, may not be so good for the implementer. And based on those precedents, we can certainly say that the courts in India will be inclined to grant interim injunctions, considering also the fact that the trial and the final adjudication by the Court of First Instance certainly takes time. It may take 3 to 5 years, depending upon the jurisdiction and the court, but still it is a good sign the good development beginning 2013 onward. So far, we can say that the enforcement scenario in India from the innovator points of view there is some clarity that the multinational innovator company look towards, and given the facts that India is a very huge market for the SEPs in the telecom sectors or or any other, considering the consumer base and the number of handsets, the number of networks we do have. So this is early days in my view. It may take a year or so to have some kind of genuine precedent based upon the trial. Thank you, Patrick.
Thank you, Sanjeev. And Deepak, if I could ask you for additional comment or other areas, I think that's a great summary of the ex parte injunction status here in India, which is something very peculiar to us in North America. We have difficulty in the States of even granting injunctions post-decision. So, Deepak?
The grant of interim injunctions have to be viewed especially from the Indian side, meaning thereby that the time being taken by the Indian courts to dispose of an entire trial. And if you look at that, and as Sanjeev said, it can take anywhere between, at the first instance, anywhere between 3 to 5 years. The interim state is nothing to do with the legality. It has to do with the balance of convenience and the equity side of it. And when we look at the equity, the principle is that both parties should not gain out of the pendency of the litigation. Neither party should gain out of the pendency of the litigation is what the primary part would be. On one side, we have the innovator who already has agreed to grant the license on a frank term as opposed to demanding anything of his choice. That's an upfront commitment which has been made by him. So what is left out is that he is unable to, retract back from that and demand for a license fee which can be beyond a frank licensing condition. So there comes a, equity or reasonableness from the patentee side, and the other party which has to be a defendant. He cannot be allowed to piggyback and, hold the cost of the due royalties, unless there is a huge and credible challenge which is prima facie visible on to the patentability of it, validity. There has to be a really huge credible challenge, not to the extent of normal credible challenge as what we will take up in the normal litigation, not involving a frank patent, because it's a SEP patent, so there is a declaration to the extent of standardization, essentiality side of it. People may say that the essentiality has not been validated. That's a different issue altogether. But there is a commitment. That essentiality is being committed by at least a party who has filed the application, and he is not bluffing it off to a very large extent, There is no need for him to bluff. Because if he bluffs it off, then he is, probably inviting a gelatin onto himself to subject the royalties to a frank basis. Let's look at Apple versus Samsung case and this entire scenario. Samsung litigated in USA on the basis of all standard essential patents, and it was not very favorable for Samsung when it came to the royalty rates. On the other hand, when Apple litigated using non-essential patents, the royalty rates which it was able to demand and get from Samsung was really big compared to what Samsung got offered. Despite the fact that they were infringing, Apple was found to be infringing SEPs, and the other way around, Apple was found to be infringing SEPs, and Samsung was not found to be infringing SEP, but simple patents, non-essential patent. Despite this, the royalty rate, when it got determined, the royalty was to be paid in effect by Samsung to Apple. So that is one of the bigger things that we have to be considering on the grant of interim stay. And if we consider that as a prima facie portion, and other issues such as willingness of the defendant to sit down and negotiate in good faith as to what should be the royalty rates which are applicable, what he is ready to give, all those parameters have to be taken into consideration. Many times the court, especially when we look at the litigation which have gone